Welcome to the Sidebar with a CFP. Pierce the veil on BigLaw Life, career, and money. Hosted by Matt Smith, the tour manager for BigLaw attorneys. You bill in 6-minute increments. Let's get you some of that time back. In each episode, we will have candid conversations about life inside Big Law, the real stuff they don't teach in law schools or show in recruiter brochures. This show pulls back the curtain on what it actually feels like to climb the ranks, navigate transitions, and make big decisions in a high-stakes career. You'll hear from partners, associates, and experts across law and finance, each sharing stories, surprises, and strategies for building a life and career that works for you. This isn't a money podcast. It's a Life in Big Law podcast with a CFP in the host chair. The contents of this podcast are purely intended to be general and educational in nature and should not be construed as specifically tailored investment, financial planning, tax, legal, or other professional advice. Any investment performance referenced is purely past performance, which is no guarantee of any future performance. Nothing contained in this podcast should be construed as an offer to sell, a solicitation of an offer to buy, or a recommendation of any security or other financial product or investment strategy. All investment, tax, and financial planning strategies involve risk that you should be prepared to bear. You are highly encouraged to consult with professionals of your choosing before taking any action based on the contents of this podcast. To the extent the guest on this podcast was a client of Concert Financial Planning as of the date of the recording, the guest was not compensated for their time. Nothing conveyed by the guest should be construed as a testimonial or endorsement of Concert Financial Planning, and their experience as an investor or a client may not be representative of all investors or clients. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, iHeartRadio, and on our website, concertplanning.com. Now here's the host of Sidebar with a CFP, Pierce the Veil on Big Law Life, Career, and Money podcast, Matt Smith.
Hey everybody, welcome to Sidebar with the CFP. Today's episode is super important. I am really thrilled to have with me Amanda Pierson. Amanda helps her clients create estate plans that don't just transfer assets, the wills and trusts Amanda creates, take a load off the survivors, prevent familial conflict, and protect future generations. Whether you need a will, a trust, or a vehicle to protect your assets, Amanda can prepare a customized plan that will help you achieve your goals. Amanda enjoys counseling her clients on how to use their estate plan to protect their legacy and provide for their loved ones in the event of death or incapacity. Amanda graduated from the University of Texas Law School, Hook'em Horns, in 2014. During law school, Amanda served as an associate editor of the Texas Law Review and graduated with honors. Amanda is committed to her husband, Gene, a great IP lawyer, and raising her 2 young boys. Amanda, welcome. Great to have you here. Thanks for being here.
Thank you so much for having me.
Yeah. On a personal note, I trust Amanda's counsel not only for my own clients, but I've even sent my own family to Amanda to have work done and get things in order. So we appreciate you having done that. So as we record this episode, we are between Thanksgiving and December holidays. Is this a particularly busy time for you? Is this when families are getting together and talking about things, or is that all just kind of in my head?
No, it's not in your head at all. It's actually a quiet moment right now, but during the holidays, people do talk about these things with their family. And then right after the new year, it is like an explosion of new clients. That New Year's resolution, that push to get this done, all the things we put off last year, we're going to actually take care of. So it is the calm before the storm.
Yeah, I actually have sitting here on my table the information for my loved ones that you sent me because I have clients currently that are going to be with family, like, the 1 or 2 times per year that they get together. And this is some of the stuff they need to discuss. So it's a really handy booklet you have that helps everybody document what things are, where things are, who people are that are important, that sort of stuff.
Thank you. I'm glad that's been helpful to you. I found that I do probate as well as part of my practice, and probate is the process of actually bringing these wills to the court and getting an estate set up. So one of the things I've found over the years has been that clients struggle not necessarily with the legal, but sometimes with just knowing what assets their loved ones had, where they were, really needing a roadmap of what to do. And that missing piece is why I created that booklet, to try to help give a vessel for communication of that practical information.
Yeah, that's very cool. I could imagine the logistical part of it. I think even when people have discussed things, just the how, what, where, who, all that kind of stuff. So I'm gonna shift gears here a little bit and talk about, my clientele are typically on the younger side, not all of them, but the majority of my clients are probably age 40 or lower. They may have children at this point. If they do, they're relatively young, or maybe they don't have children yet. Help me explain to these clients why they absolutely must, without a doubt, no question, have to get at least some documentation done in the umbrella of estate planning.
Well, first of all, I think we're all in some level of denial that these things can happen to us, right? We tend to believe that we know we'll die one day, but that's a much later problem for us.
My stock portfolio matters so much more right now than
right,
stuff.
That feeling. And I can tell you that with estate planning, you just don't know. You don't know if something's going to happen to you, or alternatively, maybe you're just simply incapacitated, right, for a period of time. Once you're out of commission, so to speak, it's really expensive and difficult to backtrack and create these documents and fill in the roles that need to be done. So what I will tell you, particularly if you have any minor kids, estate planning is critical, because if something happens to you or your spouse or the other parent of your children, it is not a quick and easy process. It is an expensive and drawn out process. And the money that should be going to your family is going to go to your attorney and the court system. And it's a nightmare, and your family will be mourning you and also really dealing with this administrative mess. So I think the more you understand about how difficult it is to go through probate without a will, particularly when there are kids involved, the more you will be encouraged to get your planning done and have something in place.
Right. And so I know that you and I are here in Texas, and it's my understanding that the system is different at different states, but let's say here in Texas and many other states around the country, if a person has listed their minor child to inherit an investment account, let's say, or be a beneficiary, what happens here in Texas? And then listeners, it may or may not occur in your state, but it's relatively common from my point of view.
So the financial institutions are not going to cut a big check for a newborn child, right? That's just not, it's not allowed. You have ways to transfer assets to minors, but what I see far too often when my clients come in is they say, well, I named my spouse as the beneficiary on everything, and then my kids as the contingent.
Yes.
But their kids are 2, 4, and 6, right? That's such a common scenario. And they said, well, that's better than nothing, but it's not necessarily better than
right.
You would need a court imposed trust in most situations. So independent administrator, if you don't have a will of your estate, would have to go to court, would have to establish that these funds have been provided for a minor. You would need to get an attorney ad litem for the minor. I mean, there'd be a lot of different steps to make sure that this was in the child's best interest, but ultimately you would get a trust that the court set up. The court would decide who's in charge, and the court would decide when it ends. And it pretty much always ends between 18 and 21, which is very young.
It's not
most
want.
People don't really want their kids at 18 going into college with their full inheritance in their bank account. It's a recipe for disaster, and it's expensive to get there in the first place, because the probate proceeding and the court oversight is going to last until the trust is terminated. So you're looking at, a decade or more sometimes of court involvement that you pay for. in that trust.
Yeah. So as I say to people, listeners, if you don't have your own plan in place, the court is going to make one for you. And in all likelihood, the oversight of that is going to end sometime between age 18 and 21. And your beautiful, wonderful 4-year-old today is going to inherit probably money that you wouldn't necessarily be comfortable with at that time. And you don't know in the interim who the court is going to name as the person to oversee it. So there's a plan. It's just not your plan.
It's not your plan, and your loved ones know it's not your plan. So, something that is special about creating an estate plan is that your loved ones, when they do, or if they do inherit from you, they know it was intentional. It was a gift from you. This is what you wanted for them. When you let the estate plan kick in and you do nothing, you've taken that away. It is a default that fell into their lap. It doesn't have the same significance. It's not treated with the same importance. So there's, we work so hard our entire lives to provide for the ones we love. It's amazing how often we don't do that one small piece, which is the estate plan, that will make sure that the work we've done is actually paying off.
Right. And I'm just thinking of all the different roadblocks that get sent up. So I can use my own personal case. When we had our documents done, I think we only had one of our children. And some people might say, well, we plan to have 1 or 2 or 3 or 10 more. And so we'll wait because we're just going to have to redo them in a few years anyway. That wasn't the experience that we dealt with. Do you want to talk about how that can be dealt with if people plan to have more children in the future?
Yes, I think a lot of people think that they will do their planning once they have reached some finality in their life, right? They think, I'm going to get this house, I'm going to start this business, I'm going to move, I'm going to have more kids, like you said. And all of that can be accounted for in your plan. The child example in particular is a situation where we will define your children as, your daughter plus all future children born to or legally adopted by you. So the fact that you go out and have 5 more kids, you don't have to do a single revision to your plan. It's already taken into account. There's absolutely no reason to wait until you're quote unquote done. And that's just this misconception we all have about things in life, that we will ever reach a point where we are.
Yeah, you're never done.
You're never done.
You're never done. Your task list, welcome to adulthood. Your task list is never finished. It never will. And it's something that just needs to happen now. Okay, so what about my clients who don't yet have children? If they somehow unluckily wind up incapacitated in the hospital, is it a really fun thing for their parents or siblings or other loved ones or friends to have to go in and figure out what it was that they would want to happen to them in terms of their medical care, their finances? Like, is that an enjoyable thing for those people?
Or is it not an enjoyable thing? The other thing to keep in mind is that particularly for the financial decisions, you'll most likely need a guardianship. So a guardianship is a process where a court would actually come in and say that, hey, you, Matt Smith, are no longer of sound mind. You can no longer make legal decisions for yourself, right?
Right.
Now, example of that would be client has a small business, right? Owns property, whatever the situation is in a car accident, has some sort of a brain injury, is unable to communicate or function. For somebody to impose a financial power of attorney or some sort of authority over that person's assets, they can't just do it on their own. They need to go to the court to get that. So that just becomes a really drawn out procedure. It becomes really expensive, and it becomes a burden for your family who's helping you.
Yeah. Who's already burdened, who is already really probably not in a great place just due to what's happening with you.
Not in a great place. They have to come up with minimum $5,000, I would guess, to go forward with a guardianship. And hopefully the right person does it, because it might not be the person you had in mind. Our parents, they're getting older. And A lot of my clients I see don't put their parents in decision-making roles for them. They tend to put siblings and peers in that role simply because they know that their parents are only getting older and it's kind of time that we help them, right? Not
Yeah.
that they're doing more to take care of us. So
Right.
so chances are the court's going to appoint a parent and it's going to be the wrong decision thousands of dollars and months down the road.
Right. And it could have been taken care of, I imagine, for fewer dollars in advance. Like if you have the documents put together, that I think most people don't even realize that this kind of preparation can fall under the umbrella of estate planning. Cause that term, I think it makes everybody think of like Scrooge McDuck or something, like diving into a pot of gold.
Piles of
Yeah.
gold.
And everybody thinks, well, I have $200,000 in student loans and I don't own a home yet, or I don't have what I would think of as an estate or wealth yet, but you've got a body and you have a brain and you need to use it and get these things done.
Absolutely. There is no minimum, right? I
Yeah.
wouldn't say that you are too poor to need an estate plan. We all need something. I even do packages for people who are going off to college, right? To make sure that their medical power of attorney and financial power of attorney and HIPAA declarations and guardianship declarations and all of these, we call them ancillaries, but they're all part of the estate planning package. And they're important because if something did happen to you, the least you can do is make that administrative side easier.
Yeah. And let's talk about so just to confirm, the relative cost of someone going and getting these documents taken care of up front, is it typically the same, lower, or higher than if they have to go through a difficult probate process or go to the court?
Yeah, it is significantly lower, probably 20% of the cost, right? It's probably about 4 to 5 times more to do this in probate. And not only does it cost significantly more, but it takes a long time. When you die without a will, you have an attorney who's interviewing people who knew you. You get witness testimony as to your life. And those witnesses, those family members and long-term friends or what have you, they have to testify in court as to you and your family history, right? There's no secret children we didn't know about. There's no, secret siblings, right? They're just wanting to make sure that all the heirs, the legal heirs, are found. And that's, it's an imposition. It's expensive. It's an imposition. And even after that imposition and burden is done, the right people don't wind up inheriting.
Right. And it's all done under duress, which is not the right way to really do any planning or anything like that. Okay. So then let's say I'm making a convincing argument for my 30-year-old attorney to go get a package of documents done. It's been my experience, one of the first things that we talk to them about are, do you want a will or a trust? Yeah. And they may say something. Let's say my 30-year-old client has a child. They often confuse a trust with what I'm going to call a springing trust. You'll tell me the right name for it, but can you talk just kind of like the differences there?
Yes. So what I would say is, and when I talk to my clients in that first meeting, I say, don't tell me about how you want to disperse the money or anything else when making this decision. This decision is based on, do you want to avoid probate or not? Because a will can contain all of the language and terms to create a trust, and it can control when money goes to kids. It can spread it out over time. The will itself can be used as a trust. It's known as a testamentary trust, which is a springing power, right, that comes into event at a future time. The difference between that sort of a trust and a standalone living trust is that the will itself has to be probated with the court in order to have any force and effect. So ultimately, it's not about if you want to have control. It's not about if you want to set up money for your kids for the long term haul or anything like that. It is just simply a question of, how do you feel about avoiding probate? Potentially, if you are in a situation where you are worried about incapacity, how much incapacity planning do you want to do? But that's really kind of in a nutshell what you're looking at with the trust-based plan.
Okay. And so if I'm talking to a client about a trust and they may ask a couple of questions in response. They may say, I thought that getting the will would help me avoid costly probate.
Yes, it avoids an heirship. So there's two different types, generally speaking. There's more nuance than that, but there's two types of probates we usually see. One where you're actually probating a will, and one where there's no will, where they have to first determine who the legal heirs are, who inherits under Texas law. When you're probating a will, you're typically going to be done much faster and for probably half the cost, right? It'll be a simpler procedure, and the person who died's wishes will be honored, right? So those are all good things with the will. But a will does go through probate. And it is a huge misconception. I get phone calls all the time. Why do I have to go through probate? My dad had a will. Well, how does the bank know that that will is valid?
Right.
How does the title company know that? Well, you could have just typed up something very self-serving and carried it in. The probate process is the court's way of making sure that, yes, the will is valid. And there's a period where people can come forward with contests. And if there is an issue in the will, they will have the witnesses to the signing testify. There's a procedure at the end of which the executor of the estate is given official documentation from the court so they can act on your behalf.
So, right. So in one scenario, you have a will in place. You take that document to the court to be probated, and the court can look at it. They can see it. They can validate it, and they can say, great, this is what's going to happen. Yes, technically we're doing a probate, but we're done here. That we've got what we want. The other option is that you don't have a will, and so there is no roadmap to be handed to the judge, and that's when the probate process gets out of hand and gets more expensive and more of a hassle.
Exactly.
Okay, and so on the trust side, the client might ask me, well, why would I want to avoid probate altogether? And usually my answer has to do with privacy, but do you want to elaborate on that?
Yeah, I think, the answer really comes down to what probate is, which is that court process, right? Court processes such as probate are public records. So somebody could see your will. Depending on your assets and debts, you will most likely have to file some sort of an inventory, which is a list of all the things that you have, right? All of your assets will be public record. Now, do people sit around reading the probate court records on Sunday morning? I mean, I don't know. Well, I'm an estate planning attorney, so yes, I know people who do, but most people don't. That's not like a normal activity. So privacy is just one element of it. The other elements are really cost, right? It costs more to probate a will than not.
Yeah. Sure.
Right. So you save some money then when you're going through so you don't have a probate process. So you're saving some money and you're saving some time. So if you're in a situation where you own this business and it's important that operations continue the next day, you can't have a delay. Your kids have, special needs and expenses piling up, and your guardian can't afford to pay them out of pocket while they wait for 3-6 months for probate to go through. Those would be situations again too. So privacy, yes. Worry about a time delay. That's a big one. And worry about a cost, the additional cost of probate. Those are the big reasons. Another one is for a smaller group of people, but people that own real estate, real property, including mineral interests outside of the state of Texas. You would have probate both in Texas if you lived here, and then also every state where you own that real property. So I will have clients with the rental home in Florida and the mineral interests in Oklahoma, and they might have multiple different probate proceedings. You have to get an attorney license in each of those states to help you. Suddenly the cost starts to mount, the delay mounts, and every state again, different probate procedures. Some states do tax the percentage of assets passing through probate. So you could really be driving up the taxes and costs there depending on the states that are involved.
Okay. So listeners, if you're first asked something along the lines of have you decided whether you want to go the will route or the trust route, the way you may think about it in your head, and Amanda, to clarify any of this if I say it wrong, setting up a will in advance may be cheaper for you as compared to setting up and maintaining a trust in advance.
Mhm.
But on the back end, probating the will does go through the court system, does involve an attorney and all that sort of stuff. So the costs can go up there. Whereas with the trust, it may be a little faster and a little bit more easy for your heirs and the people involved.
Absolutely.
Okay. And for listeners, if you have parents that are kind of getting up there in age, maybe live in a different place than you, or have obtained some degree of wealth, if a person owns real property in multiple states, or like Amanda, like you said, mineral rights, that's here in Texas, it's really common. In my own family, there's small de minimis minimal rights in Louisiana, things like that. You said that, I think you said we could wind up going through probate in multiple states.
You might have to, and every state's different what they're going to require there. But the costs can add up, and the confusion can add up, and the burden, right? The administrative just doing is not what your family is looking for.
One of the things that they teach us on the estate planning side of the CFP curriculum is the real property deal, that if you run into a client that has real property in multiple states, that's a big red flag to say we have to get the estate attorney involved, because that sort of thing is often better done within a trust. Now, of course, I'm never telling somebody you have to go create the trust. I'm saying you have to go talk to the estate attorney. Yeah. But that's something that people need to think about, not only for themselves, not only my 30-year-old clients who are just getting started in life, but my 30-year-old clients who have parents who are more seasoned in life and may have accumulated more wealth along the way. Okay. How are you doing on time, Amanda?
I'm good.
You're good? Okay. Because I have like so many things to talk about. Usually I do these for half an hour, but I really want to hammer this home. Okay. So let's talk about maybe some areas where people can slip up or make mistakes. One of the things I think about is in the context of trusts, they set up a trust document, but then they do not actually retitle assets and put things into that trust bucket or whatever mental model we want to use for that. Can you talk about what we do? We created the trust. What happens? How does that work?
Yes. So when you do a trust, you are not done when you sign your trust. If you think of the trust like that bucket, like you said, Matt, it's this bucket, and you have to actually put your things into the bucket for the bucket to help.
Yeah, right.
And then transfer that bucket to somebody else when you're gone. So what that looks like is a lot of times beneficiary designations. And it's usually one of two different ways to get your assets into a trust. And beneficiary designations is the most common way, where you say, on my life insurance policy, I leave it to my spouse, maybe. But if my spouse is also deceased, then instead of writing my kids' names down, I leave it to my trust. So across every account you have the trust really as your ultimate beneficiary. Also, you can actually own the asset in the name of the trust, not for life insurance, but let's say you open a checking account. You can open that checking account so that the checking account is actually owned by the trust. So it's the Amanda Pierson trustee of the Amanda Pierson Trust is how that would look. Again, it's my account. I can do whatever I want with it. I can close it. I can spend it all,
Yeah.
It doesn't matter, but it is owned already by the trust. So if something happens to me, then the trust will say, who's the trustee after Amanda's gone and who's the beneficiary after Amanda's gone? And it'll just kind of continue once you're no longer there.
And that's written into the trust, who those people are.
In there. Exactly. Yeah. If you don't put your things into the trust, you're not completely out of luck. We always do a pour over will. And the pour over will says, I leave everything to my trust, right? If I happen to have an asset that didn't make its way into the trust during my life, I leave it to my trust on my death. But that pour over will has to go through probate because wills don't have force and effect until they have gone through probate and gotten the court's approval.
Yeah.
So you've done all the work and spent all the money of a trust, but you haven't fully avoided probate. It can be better than nothing in the sense that all the assets in the trust, they will move right away. So you'll have some liquid assets right away, but you won't ultimately avoid probate, which is really the whole point for most people.
Yeah. Okay. So pour over will in our mental model, it's like you are your own bucket. And once you kick the bucket, then your bucket's going to pour over into the trust.
Mhm.
Okay. And so retitling accounts. So like from my perspective, sometimes I will see investment accounts retitled to be in the name of the trust. That trust is a separate legal entity. Is that right?
Yes and no. Now, it's a disregarded entity for tax purposes. So it is separate from you, but it is tied to your social security number during your life.
Okay.
Once you die, or if you're married and you have a joint trust with somebody else, that becomes irrevocable on the death of the second spouse. Basically, once the people who created the trust are no longer with us, the trust goes from being a revocable living trust to an irrevocable trust, where it gets that full tax entity status, gets an EIN number, has to have a separate tax return, and the terms of the trust can no longer be changed. So if you have that trust continuing on for your kids, the new trustee can't say, and I'm going to redirect everything in here to myself, right? There's some limitations on what they're able to do.
And just for my sleuth listeners out there who may know enough to be dangerous to themselves, the revocable trust that we're talking about that exists during our lifetime, that does not shield you from estate taxation or anything, right?
No.
That's a different kind of thing that we are not talking about, at least not yet right now.
Let's not talk about that yet. That gets very complicated very quickly. It's incredibly interesting, but with the exemption being so high, it's not relevant to most people.
Right. Okay. And so if I'm thinking about, oh shoot, I did a trust, but I never put any assets in it, which as a financial planner, I've seen this from time to time with I don't have a lot of older clients, but I do have some older clients, and they'll have a trust that the bucket is there, but there's nothing in it. And you really have to get on them to retitle things and put things in there. Now, what if you're a younger client and you have that, testamentary trust, that springing trust that comes to life within your will in the event of your death? That's not the same thing. We're not retitling assets to go into that trust, right?
You're not retitling assets, but I also will use that as a reminder inflection point. Most of my clients with kids have put their children down as beneficiaries on their accounts. That is just, I would say 99, like not exaggerating. I would say 99% of my clients, if you look at their, brokerage accounts and life insurance policies, et cetera, well, if they have beneficiaries on them, will have their spouse and then their kids listed. So the thing to keep in mind is always that with the testamentary or with any plan, your beneficiaries supersede what's in your will. Yes. So if you've listed your children, it actually can be problematic. You really need to either direct the money to the trust under your will or just leave it blank. If you're going through probate, it's fine to leave your beneficiary, leave them off, leave the kids off. It will get to the kids under the will, meaning it will use those testamentary trusts that you've set up for your kids and bring that structure to their inheritance. So even with a will, sometimes we do have to do some beneficiary updating just because of confusion people have with the state of the law.
Yeah. And for all my listeners who are not going to die within the next 150 years, and therefore you really don't want to deal with this process, it's still not a good idea to not get the will done and just say, well, I'm just going to leave my kids off entirely and let it go through probate, because you don't know what the courts are going to do. Maybe they will, maybe they won't. And maybe they will name the conservator, the people that are going to take care of the kids in the meantime, who you want them to be. And maybe they're not. So I get lit up about this. It's one of the first things we do in the planning process. Is our first phase of financial planning is resilience. We want to make sure that you're resilient to financial shock, and estate is part of this. And almost every single person I see that has children has named their children as a contingent beneficiary, and just like you just said. And so you mentioned something in there that I really want to highlight. Let's say that a family does go through the process and they do get a will set up, but they forget to update beneficiary designations that align with what the will says. The beneficiary designations on your retirement accounts and on your life insurance accounts, am I right about that they are going to supersede what's in the will?
For the most part, I mean, for your spouse, 100%. There's no pre-terminated spouse protections. Pre-terminated meaning there's no protections for if you later get married and that spouse that you have later has not been recognized. Now, there are some legal protections for children who were born to adopted by you after the date of the beneficiary designation, but that starts to get into an entity by entity determination of how they handle that. Do they change the designations to reflect what the fact that the kids didn't exist yet, or do they go by the beneficiary? And if they even do change to reflect the fact that the kids weren't there, you've omitted the spouse, and how are the kids going to get the money? You're back in square one with the court imposed trust. So it's just not a good thing to have the wrong beneficiary on the account.
Right. And I actually have a scenario at this time where what the will said differed from what the beneficiary designation said. And it's not even anything they're going to fight. It's just they're going to let it go the way that it went. And it's causing undue stress and duress. And, it's just it's not a good place to be in. So when you get the documents done, whether it's a trust or a will, there are still some things that need to happen. And one other thing I'll flag, I don't know if you have comments on this or not, but some of the financial institutions also want you to fill out their own documents and their own forms along the way too. So you think, oh, I have everything documented,
but
I've put it all in a file. I have it ready to go. I've signed everything. I have the original documents. And then the large national multinational bank says, yeah, no, that's all well and good, but you should have filled out our form as well.
Right. And that's very frustrating to me. And I tell my clients that, particularly when it comes to the statutory durable power of attorney, which is your financial POA. Mm-hmm. And I say, look, this should be all you need. But unfortunately, a lot of these banks have their own forms that they want you to fill out, and you don't know about it till it's too late. Yeah. So if you do feel like this is an important asset, maybe you're going to be traveling, you name it, call your bank on top of everything else and make sure they don't have anything else that needs to be signed. Now, it's very frustrating because it should not be legally required and just creates extra work and complication for my clients, but that is absolutely something to be aware of.
Well, and it seems like what happens is, and this happens with all sorts of customer service situations, is that the first person you call to say, hey, I have the legal documents. I'm sorry I didn't do your form, but here we are. Yeah. The first person you talk to is just going to know, well, my giant bank that I work for has this policy they tell me to follow, and so therefore we're going to follow it. And it may be 3 rounds of phone calls and emails and certified letters and correspondence before you get someone in a position of authority who can actually honor what's written in the legal documents. And it's just something you don't want to have to deal with. And so I feel like as I'm bringing these issues up, a listener that's listening to this on the way to work in the morning might be like, my God, I have negative time in the day. I've got a full-time job. I have children. I'm, all this sort of stuff. I have no time to deal with this, but I just want to stress for you that these types of things can be those one and done sort of things for years at a time, where you're not necessarily going to have to revisit them unless you have a major life change. And so it's annoying, but if you deal with it now, it is far less annoying than dealing with it later, especially for the people in your life, because it's likely not going to be you dealing with it in the first place.
Absolutely.
So let's see, what do you have any stories you'd like to share that can kind of serve as warnings for people, or maybe alert them, kind of get their attention?
Yeah, we talked about minor kids, but another whole area of issues comes with blended families when they don't do planning. I think one of the things to keep in mind with blended families is that and by blended families, I mean, let's say you've got a husband and wife had kids before the marriage with somebody else, right? Mm-hmm. So there are these kids that aren't also the husband's kids. Now, something happens to the wife, right? If she passes away, everything she has goes to her kids. Nothing goes to her husband, okay? And that is grounds for a whole host of issues. Everything from now the husband is co-owning his own house with these children who might be minors, who might be under the care of an ex-husband, who might not care for the new husband. I mean, there's just so much there that is problematic. Sometimes the client is much older when this happens. Maybe they don't even have a relationship with one of the children, right? It is messy. It is really, really messy. So I would say, anybody with a minor child, stop what you're doing and get a plan. But anybody who's part of a blended family, they should take it as just as seriously, because I see it over and over in my probates, really how damaging it can be to a person's finances and relationships with the kids and all of that, just based on how the probate shakes out.
Right. And so that brings to the forefront these kind of life events that they really do require. So earlier in the episode, I was talking about you can get documents in place that will account for future events, like maybe future children, things like that. But what are some things that certain life events where you would say, hey, you really do need to take your estate planning documents back to the attorney and have a review and see whether things need to be updated?
Well, when something changes to the point where you no longer want the person designated to either serve or inherit. So let's say you wanted your kids to go to your sibling, your sister's just the greatest, but then your sister went and had triplets and cannot take your kids and is broke, and all these things are going down, and you realize, well, actually my husband's sister would be the better fit, right? At this point.
Yeah.
That would be a situation where we can't really account for that, right? In the planning at the outset. So that's like a real life circumstance. Now, if the first person dies and you have a second person listed and the second person is a good fit, you don't have to do anything for that. But sometimes just, your relationships change, the life of the person you have designated changes, and it just might require a shift. Similarly, your kids could grow up to be a little bit different than you think that they will. Maybe they have drug addiction or health issues, or a spouse, filing for divorce, or things that are occurring in their lives that make you realize you want to distribute the assets a little bit differently. And those are also situations where you probably have to go back in and do some changes.
Yeah. Okay. So the phrase you used was perfect. I'm going to try and memorize that, but I think you said if you want to change who inherits, or what was the phrase?
I said most likely who is in charge of decisions, or who inherits, the people, really the people or the structure of the plan. You're looking at doing some revisions, getting a new house, selling a house, having more kids. Those actually, those things typically don't necessitate change.
Okay. Cool. So on the more advanced planning side, I have a lot of clients who get phone calls at their desk trying to sell them. Now, this sounds out of left field, but I'm going somewhere with this. People that get phone calls at their desk purporting to sell them this wonderful, miraculous product called whole life insurance, which will solve all of their tax problems, all of their investment problems, all these guarantees, never lose a dollar, yada, yada, all these sort of things. My reaction is typically asking questions like, do you have children? Do you have anyone who actually needs insurance from you? And usually the answer is no. But anyway, often I will tell them, ask your estate attorney whether you need whole life insurance as part of an estate plan. And I'm really throwing this curveball at you. We haven't discussed this ahead of time, but I'm thinking of things like the irrevocable life insurance trust or things like that. Have you seen a use for whole life insurance that is valid within the estate planning world?
Only for taxable estates. Okay. So, and by taxable estate, I mean an individual's estate who's starting in 2026 is over 15 million, a married couple whose estate is over 30 million. You could get into a situation there where it's good to have life insurance held under an irrevocable life insurance trust. It's not part of your taxable estate, but is just immediately transferred to the designated beneficiaries. But I mean, in the estate planning contest outside of, and I only suggest these ILETs is what they're called. I only would suggest those for a taxable estate or estate that's clearly on its way to becoming taxable. Otherwise, no, it's a waste of time and money. And it locks you into an investment that may not be flexible. Of course, financial advice, I defer to you, but no, it's rarely the way to go, except for a few.
There you go. That's
lucky people.
Okay. So we say the same thing. We cannot We can't give any financial advice, and therefore we can't just make a blanket statement. So I'll just say it's rarely the right way to go. And often when I do see it being the right way to go, it is in the context of estate planning rather than investment planning or direct tax planning. I guess the estate planning part has something to do with taxes. So listeners, irrevocable life insurance trust, ILIT is the acronym, and it's typically most relevant to individuals that are worth 15 million or more, or couples that are worth 30 million or more, given where the estate and gift tax exemption is today. So it's not terribly common. That's one thing I wanted to call out. What else here? Is there anything else that I'm not bringing up that you think we could cover or want to talk
The
about?
last thing I hear a lot of questions on that's not relevant, like the ILIT, would be irrevocable trust planning. And again, in my opinion, irrevocable trust planning is for 95% plus of people, it's for tax planning purposes. And by tax planning, I mean estate tax planning, not income tax planning, estate tax planning. It's probably going to be bad for you on an income tax level, if anything, right? Or on a capital gains tax basis, it's going to be bad for that kind of basis adjustment once you die. But for estate tax purposes, that's the only time, or one of the only times you're really going to go with irrevocable trust planning in Texas, that is. But people hear about it all the time. They get these ideas that they're going to be creditor proof and they're going to save all this money in taxes. And it is a misnomer for most people. So that one is another one that I would caution against.
Yeah, it gets eyeballs on TikTok and Instagram and things like that and sells ads, but it is rarely the right thing. One thing you just mentioned that I kind of want to take a step back and just identify for people: federal income taxes are what you're paying on your income from work. Okay, so if you're a listener to this and you're on your way to your law job, and you get either a W-2 salary or you get a K-1 partnership, you're paying income tax rates. And so maybe you're paying a marginal 32% or 35%, or in the event that you qualify for the highest income tax bracket, 37%. But you have a long way, you have a large amount of dollars coming into your orbit before you reach those top tax rates. So like if you're a married couple, I'm going to get this wrong, but somewhere around $650,000, $700,000 in taxable income is where you start paying these highest marginal tax rates. There is a whole separate, totally different system that is gift and estate tax, in which after you're deceased, you may or may not owe tax rates. And if my memory is working, you're going to owe 40% very quickly on that. The threshold for which you owe these enormous percentage tax rates is far, far lower than the ordinary income tax system. Yeah. So those are situations in which you're going to want to plan, and working with an estate attorney can save you and your heirs giant, copious amounts of money with proper tax planning. Most of my clients are not in a situation where they need it yet, but they may be. In fact, I think, I don't know how long ago it was, but these large exemption amounts of 13, 14, 15 million are not the norm, and they could revert back to much lower exemption amounts.
You know what? We'll see what Congress does over the next 10, 20 years, but these things could change, right? There are laws to create the exemption and put it where it is today, and there's the new laws could be passed. So there's no way to say what we'll be looking at in 10 years. But just like you said, Matt, in the past, the exemption was much lower. I look at the probates I have, maybe there was a will prepared back in the 80s, right? It's probably very heavily tax planned relative to the size of the estate, at least from today's perspective. And that's just simply due to the change in laws that we've had.
Right. And so for perspective, listeners, if today's exemption is $15 million, then you could theoretically, generally speaking, have $14 million net worth, and that can pass without taxation to your heirs. But if the estate tax exemption were to drop to 2 million, 1 million, 4 million, whatever it is, all of a sudden the value of your estate beyond that point is at risk. And that is a much more real risk for a lot of people. And that's where the tax planning stuff comes into effect and becomes much more important for a broader swath of people. And so you always want to be on the lookout for that. And I would just throw out there that if we do see anything like that happen, which is a distinct possibility, that's definitely when everyone needs to revisit their documents, and it could call for a different strategy changes.
Absolutely.
I think the last thing I want to say is I'm just kind of glancing over at my computer.
Yeah.
I have, as I mentioned earlier, I have your handy booklet to document things. But for some of my clients who maybe were more digital native, I was born in 81, so I'm somewhere between millennial and Gen X. One thing my wife and I do is we share passwords via a password keeper. So in our household, we use LastPass. And within LastPass, any accounts, anything that we may have a common need for, you can have share settings with somebody that have embedded security features such that my spouse can't go get a password just whenever she wants. There has to be some delay of time within which the password vendor cannot get in contact with me, can't reach me. At that point, they'll unlock it and let her in. And I think there are a lot of tools and things that people can do electronically in order to set themselves and their family members up for a much easier process. Because at this point, I think in my LastPass, there's probably at least 1,000 passwords and notes. You can, you can leave notes. Where is this? Like one of the things in your guide is safe deposit box. Where is it? And where are the keys and all that kind of stuff. And so I just want to throw that out there, is that there's a lot of digital tools that you can take advantage of to make things easier for people that don't necessarily keep a lot of paper on hand. I don't know if you've seen any other types of strategies or things like that that are maybe useful for younger generations.
Yeah, I think it depends. It gets into this whole legal quagmire, right? Of, well, are you allowed to use that person's password if they're no longer alive? But during life, a lot of times what people will have is check writing authority, right, on various bank accounts, savings accounts. Those terminate when you pass, but if you're ever in a period of incapacity in particular, those sorts of things can be really helpful to give your loved ones the ability to jump in and do what needs to be done.
Yes, thank you for saying that. I didn't, sometimes I think about the more logistical stuff, not with the attorney's eye. So you may not be validly allowed to go use somebody else's passwords after they are deceased. And clients may want to have a conversation with you about when to notify and how to notify institutions and things like that in the event of someone's passing or incapacitation. But that's all stuff that I think you can help them out with as they come to you for counsel.
Absolutely.
Cool. Okay. Well, this is officially twice as long as any other podcast that I have done. And this is
wonderful.
Yeah, this is super, super important for me to try and pound the table and bang the table and tell listeners, nobody cares about NVIDIA stock or what your investment account is doing in the event that you die young. And you have children or you have loved ones that need to be taken care of, or more likely you become incapacitated in some way and you're laying unconscious in a hospital room and no one knows what your wishes are for care or for how to deal with financial matters. Business owners, especially small business owners, this kind of stuff is absolutely critical. So to me, the reason we attack resilience planning first is because although it is, no offense to you, Amanda, but it's just the lamest part of the financial planning thing that we do. It is the least fun to talk about and deal with. In many ways, it's the most important and the most urgent thing to deal with in most cases, because retirement, if you're my 30-year-old big law attorney client, your retirement, unfortunately, is a ways away.
And you're probably going to be okay, right?
But we don't know when this other stuff is going to become important. And the absolute nightmare situation is I've been working with somebody for years and something happens to them and they have not gotten this taken care of. And then the spouse, the survivors, the children, I'm sitting there thinking to myself, wow, I have failed in my job in financial planning because this did not get planned for. And it was so important. So I am begging listeners, take this seriously. This is stuff that needs to be taken care of. Amanda, for my listeners in Texas, where can they find you if they want to reach out?
Yeah, well, I'm with the Heights Law Group. I'm the owner of Heights Law Group. We are an estate planning and probate firm located in the Houston Heights neighborhood. So anybody who's in the state of Texas, I can do work with on planning. But of course, if you are in Houston, it'll be more convenient for you to come on by my office. So again, Heights Law Group in the Houston Heights area.
Cool. All right. Well, thank you so much. I really appreciate you being here. I think it was a really useful discussion, and look forward to having you back again in the future.
Sounds great. Matt, thank you so much for having me.
You bet. Bye.
Bye-bye.
You've been tuning into Sidebar with a CFP. Pierce the veil on Big Law Life, Career, and Money with Matt Smith. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, iHeartRadio, and on our website, concertplanning.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others. The contents of this podcast are purely intended to be general and educational in nature and should not be construed as specifically tailored investment, financial planning, tax, legal, or other professional advice. Any investment performance referenced is purely past performance, which is no guarantee of any future performance. Nothing contained in this podcast should be construed as an offer to sell, a solicitation of an offer to buy, or a recommendation of any security or other financial product or investment strategy. All investment, tax, and financial planning strategies involve risk that you should be prepared to bear. You are highly encouraged to consult with professionals of your choosing before taking any action based on the contents of this podcast. To the extent the guest on this podcast was a client of Concert Financial Planning as of the date of the recording, the guest was not compensated for their time. Nothing conveyed by the guest should be construed as a testimonial or endorsement of Concert Financial Planning, and their experience as an investor or a client may not be representative of all investors or clients.